just wanted to, well, I shouldn't object again to her representing me because, like I said, I'm always of the position to present myself as a man, so I'm not going to give up my right to do that. But I will contact her if you guys are going to force me, so to say. It's only going to be it's by force and not giving no other option.
Thank you, sir. Your objections are noted, and I'll see you back here on February 1st. State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eric Martin.
You here as standby counsel?
I'm here as standby counsel.
Do you know where Mr. Martin is?
I am shocked. Mr. Martin has almost called me every night. I did attempt to call him earlier. It sounds like his phone must be off because it said not accepting calls at this time. So I guess on his behalf, I will be asking for an adjournment because, like I said, I talk to Mr. Martin every day.
Ms. McDuffie?
Well, Your Honor, I guess I will inquire of standby counsel, recognizing that he does not want any attorneys in this case. We adjourned, I think it was just about 2 months ago, because Mr. Martin wasn't able to review the video in this matter, and he was supposed to be hooking up with Ms. White to do that. So I'll ask if they were able to do so. And where that stands, I'm not requesting a bench warrant because he makes sure that he comes every time and talks quite a bit. So I'm sure he wanted to say more today. So this will be his first failure to appear, but I just want to know where we are with the case.
We watched the videos, yes.
Good, excellent, okay. So I don't mind a show cause.
Show cause and pretrial will be scheduled for March 14th, 2022 at 9 a.m.
Good morning, Mr. Martin. Can you hear me? You're muted. Now calling case number 23S00425. This is the State of Michigan versus Eric Martin. Can I have appearances for the record, please?
Stephanie Cannon with the Washtenaw Public Defender's Office on behalf of Mr. Martin, who is present, Your Honor.
Thank you. Mr. Martin, can you please state your name for the record?
Capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N.
Okay, thank you, sir. Today is the date and time set for an arraignment in this matter. What I am seeing is that you failed to appear for a court date on February 1st, and that you failed to appear for another court date on March 14th. Therefore, a bench warrant did issue for your arrest. Do you understand?
No, I do not understand, and I do not stand under the charges. I am one of the sovereign living people.
Okay, sir, I'm not asking you if you agree with me. I am asking if you understand the words that I just said to you.
Well, I do not understand. I might comprehend, but I do not understand, and that I do not stand under the charges. And I am not a defendant. I am a living human sovereign. I'm not the legal fiction corporate entity, all capital letter name.
Attorney,
I do not accept an attorney.
Thank you, Your Honor. At this time, he would stay on mute and ask for a PR bond.
Objection. You're not speaking for me. You're not my attorney. If you think you're my attorney.
Thank you for the attempt, Attorney Cannon. You can turn your camera off.
Thank you, Your Honor.
Okay, Mr. Martin. At this time, I am seeing that your license has been revoked. You have failed to appear for court dates in front of Judge Washington. You were to have a sentencing hearing and a pretrial date in front of her, so that is what I am going to set you for now.
That wasn't finished. Cut me off. I had more to say.
Sir, I am setting you for another. Yes, I am, because what I am doing today is arraigning you, and I am setting you for another court date in front of Judge Washington. That court date will be April 11th, 2024. That will be at 9 a.m. That will be for your pretrial and potentially your sentencing.
I can't remember all this at once. The date is when again?
April.
Yep.
11th.
Yep.
9 a.m.
All right.
That is 9 in the morning.
Okay, now. Okay, is that it for that? Okay, now. Let me ask, so does she call herself, is this a separate charge?
I'm not
The failure
entirely
to
sure what you're asking. So what happened here was that a bench warrant was issued for your failure to appear. At this time, to guarantee your appearance at the court date on April 11th at 9 a.m., that warrant will continue.
Okay, that wasn't intentional, so that's why it's baseless. It's baseless, and it shouldn't have been a warrant issue because.
Okay, sir, you've got your next court date. That's April 11th at 9 a.m. The bench warrant is continued. This hearing is concluded, and you are free to sign out of Zoom.
Well, I have more to say. I'm not done saying what I have to say. Pursuant to my First Amendment right, I have more to say here. That is,
All right, the court will call the case of the State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Mr. Eric Martin, please unmute your device, and state your name.
can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family. A living sovereign, one of the people.
Assistant Public Defender Davi Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
Yeah, I looked at the video, and I filed I looked at the video, and I also filed some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial scheduled or anything else.
Mr. Martin, I've decided on all the motions that you've brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
You may not prepare.
I think my words were very clear.
I understand what you're saying. You're saying because I didn't file it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
I mean, they're denied, but you didn't rule on it. How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not, but I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to the third one is self-incriminating. As I pointed out, stating my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're going to need to speak up if you want to have a transcript of this because it's not Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me show you.
I'm sorry.
We're kind of a little closer now. How's that?
Is that any better?
How's that?
How's that? That one clear. Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true because, as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the federal statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law. And I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now, I got to fight one about filing fees. But when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since Mr. I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law, which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as I indicated in my demand under the U.S. Constitution. Only the
Sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the May jury selection, Your Honor? Or
No, it's not. We're going to do a July 25th July 25th final settlement conference.
Mm-hmm. Okay.
August 9th.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
And I'm also going to make a demand right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery. All these court proceedings are against my right against slavery. So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. It was only under threat and duress. It wasn't by willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going
Okay.
to tell him in just 1 second.
Mhm.
All right. The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on, July 25th, 24, right? 8 p.m. a.m. You said, right?
It's at 11 a.m., sir.
You know, I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but you know.
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time. Okay, now let's do the what's the other date now? August. What else?
August 9th
Okay.
at 8:30.
8:30, and what's that considered? What's that called there?
Jury selection, sir.
Now, which is in person here now?
Thanks for watching video, like and subscribe for more videos.